Earlier this month, Mugera John, the co-accused of Muhammad Ssegirinya and Alan Ssewanyana in the massacre murder case, applied to the International War Crimes Division Court to be released on bail on allegations of illness and that he needed medical attention. The application was, however, objected by the prosecution, led by Richard Vumbuka, on grounds that he lacked substantial sureties. The International War Crimes Division Court Judge Alice Komuhanji Kauka's judgment, read by Magistrate Kemigisha Millicent, dismissed Mugera's bail application.
And court considered section 15 of the TIA, and under that section 15, subsection 4, court is only considering whether the accused has a fixed place of abode and whether the accused has sound sureties within the jurisdiction to undertake that the accused shall comply with the conditions of his or her bail. 23, that the applicant has a fixed place of abode in Chibuye 2 Parish, Makinge Division, Kampala.
Court also dismissed the ground of having hypertension raised by Mugera John on grounds that Prisons Authority can manage the illness.
That is whether there were exceptional circumstances to justify the applicant's release on bail, and whether he is likely to abscond. So on whether there exists exceptional circumstances justifying his release on bail, the applicant raised the issue of being ill, that he suffers from hypertension, palpitations, and chest pains. He furnished this court with a medical report, but from the reading of the report, court has ruled that there exists no exceptional circumstances in this case to grant his bail. This is because the medical report attached shows that the applicant is a known case of hypertension for the last 2 years, for which he has been on some drug called nifedipine with improvement. So the judge highlights the word improvement, and he says that the applicant's illness is being well managed in prison as per the medical report. As such, I find that
due to financial capacity of the presented sureties, court also declined to grant the bail.
After thoroughly examining the sureties that the applicant produced, I'm not satisfied that they are substantial, whereas it was my finding in criminal miscellaneous application number 2 of 2023 at page 22 that I would find the applicant's blood relatives or family members more convincing in effecting their responsibility as sureties. I still find, after thoroughly examining them, that the ones presented are not substantial because, from my assessment, they did not possess the capacity to prevail over the applicant to ensure that he complies with the terms and conditions of the court if bail was granted. Sureties should possess a very strong financial status for them to be found substantial. I believe, like my land sister, Honorable Lady Justice Elizabeth Jane Aliviza rightly held in the applicant's first bail application, number 2 of 2022 at page 11, that the sureties should have some credible sources of income. I find that the second and third sureties were lacking in this aspect as they did not have credible sources of income. For instance, the second surety stated that he sells motorcycles which he buys from other people. I find that this is very unstable, and this is a very unstable and unpredictable source of income. As for the third surety, she stated that she sells charcoal from her home, which business I presume is on a very small scale since no contrary evidence was adduced to the court. She therefore does not earn much. From my observation, the second and third sureties do not possess the required capacity to bind themselves to a substantial amount of money befitting cases of this nature before the applicant can be released on bail. It is very unlikely that they would be able to raise the kind of money in case the applicant absconds bail. I would find it extremely risky to release the applicant on bail with the above sureties. For this reason, I still find that the sureties presented by the applicant are not substantial to undertake that the applicant shall comply with the conditions of his bail.
After court, relatives of the co-accused of Muhammad Ssegirinya were in tears.
John naga twekuza tukuziza banaffe lero akibbabaka John zaina nanga manyini nsobola okutunda byange John ne mujja mukomera babalowooza nti sente Katonda yakutunda ne sente John tatanga kwa muntu njogera nga nte Katonda John tagendanga okutema muntu nga nte Katonda
Sirina kinyiza kwogera ku John mulabidde emyaka 25 John yajja mwana muto ku kyalo ekyange nga ndi mukulembeze up to now John akoze buli kimu nga ndaba bwe nti maaso ge sikuwasa sikuzaala tebaleeta ki abooluganda bonna baabano ebyo bamanyi we babikola bajjeko omusayo basi baganda be naye kati ogamba mbu baleese omuntu w'amanda atundira amakamanda awaka gwe babateekako nga shuwarite we toyatika okubyonna byonna kubonyabonya mwana muwalenzi
okulanya mama wa arani gwe musangu okulebeera nibo waba arani siwanyana John nga alinawo edduuka nga yabasavinga ebintu gwe musangu gwavuna na John babuuza ku kyalo ani mukwano gwa famire eno nti anko dduuka ne bajja ne bakwata John mu dduuka ali bamubuuza nini dduuka John yafa nti nze nanyini ne bamutwala ku booro nze vice chairman w'ekiyembe Moses tumwakire twala tamanyi naleeta
nze mujuzi mbayi kombugana wa John Mugera nze ndi mukulu we
bamusika ze bwafira mukomera bamuzikeyo
kojja wani andi bakojja bali mu kyalo jja bagamba bali chote bali Masaka bajja kusobola kwa sorry bagala bawo na round arafa akaunti ze tulina ko sente tukole ki bitami
bamusika ze tuchada mukushababira
ate babagala sente nze sente nze timba ku bigundi sente nitambulanga nazo oba tutunde ebyaffe abagala tubitunde tubawe sente ze bagala John ave mukomera John taina John tatemangako John yaba kudduuka lye oli bamubuuza John aliwa nti John akuyamba yaliwa nti anko John yagenda okunyamba ye John bamukwata bukwasi okitegera yali talina musango John ali ku dduuka John tatanga kwa muntu njogera nga nte Katonda John tagendanga okutema muntu nga nte Katonda bwe babaagala nja kutunda ebyange John ave mukomera babaagala sente kikaki nja kutunda ennyumba John ave mukomera babaagala sente balowooza tunaabeera na wumbi ababeera ne sente bwe babeera na wumbi.
This is the third time court is declining to grant bail to Mugera John.
I've heard the ruling that the court has made, and it has said or held that my application was not, it didn't fulfill the requirements of my client to be granted bail on the conditions of the sureties I presented not having enough financial muscle to warrant the coming to court of of the accused person or the applicant, which I'm very dissatisfied with, because in other words, court has said or is saying a person cannot be granted bail if you have no people who have enough financial muscle or people who are rich. You understand? And in my view, that is in contravention to our constitution. Our constitution, or the makers, did not intend that a person who does not have people who are rich or powerful people shouldn't be granted bail. You understand? So, I mean, my next step right now is that we shall bring another application. We shall bring another bail application to see whether we can bring back these very sureties or we can look for other sureties. But as court had said before, bring people who are relatives of the accused person. The accused person of the applicant brought his best people who knew him. You understand? So when it is it is dismissed on grounds that they are not financially well enough, then that baffles us. In essence, court is said, any Ugandan, if you're poor, even if you're charged with any offense, you can never be granted bail. Bail is a constitutional right to apply, and still a person who's charged, however grave the offenses might be, any person who's charged with such offenses, they also have a right to apply and be granted if they have sureties. So we are very disappointed with the ruling, and our next step, as I've told you earlier, will be to bring another application. That's what I can say for now.
Meanwhile, the International War Crimes Division Court, before Judge Richard Wabwire, has set 14th September 2023 to resume with the case, where 9 suspects are accusing the twin bombings that occurred at Parliamentary Avenue and Central Police Station in Kampala. Although court had set to read charges to the accused, however, this was impossible, since prosecution had just received the file from the police.
My name is Asime Anthony. I'm representing the accused persons in the twin bombing case. These are 19 accused persons who are charged with terrorism. Others are charged with belonging to a terrorist group, that is ADF, and others are charged with aiding and abetting. The last time we were in court, the state prosecutor didn't have the police file and was directed by court to produce the file today. Today in court, you notice we didn't proceed because still the state says they've just received the file and they need to to disclose the file, to give us the file copy so that we are able to proceed. The matter has been adjourned to 14th of September, and that's when we shall be able to take the necessary steps after we've seen what is on the police file or the evidence the state has against these people.
During the proceedings, one of the accused raised a concern for being tried by this court, yet by the time he was arrested, he was below 18 years.
That issue was for a suspect, one of the accused persons, who says at the time of arrest he was below 18, he was of underage, but court, as you heard, has made an order that he should be subjected to medical examination so that by the time we come back to court, that issue has been resolved, because someone who is below 18 shouldn't have been in prison in the first place, in prison of the adult persons. So we're waiting for the medical report so that then court makes a decision because children should be tried differently or separated from adults.
Who is he and how old?
I'll not disclose the actual age as of now because what the police file says is different and what the accused person says is different. So it's upon getting the medical report, the confirmation, that we shall determine, or that court will determine his actual age. As of now, we can't go by what he's saying, or we can't go by what the police file says. The name, I think, is called Kuikiriza, something. I need to cross-check on the file. I don't have the name quite offhand.
Prosecution in this matter is represented by Chomuhendo Joseph, and the accused persons are represented by lawyer Anthony Asimwe.